There are over 1 billion profiles within the actual Eightfold system. Let's say 50 million people who've been impacted. How are they notified? Are they notified? How are they notified?
The good news is our listenership is about 50 million. So that'll cover most of the people that know about this now.
Hide your kids. Lock the doors. You're listening to HR's most dangerous podcast. Chad Sowash and Joel Cheeseman are here to punch the recruiting industry right where it hurts. Complete with breaking news, brash opinion, and loads of snark. Buckle up, boys and girls. It's time for the Chad and Cheese Podcast.
Oh, yeah. Two guys whose favorite class in high school was detention. Hey, kids, it's the Chad and Cheese Podcast. I'm your co-host, Joel Cheeseman. Joined as always, riding shotgun is Chad Sowash, as we welcome Rachel Dempsey, Associate Director at Towards Justice, a nonprofit legal organization that defends workers on their way to being knee-deep in the Eightfold lawsuit. Rachel, welcome to HR's Most Dangerous Podcast.
Thank you. It's great to be here.
Rachel, how do you become an esquire? I don't know anything about this. Go to law school.
Go to law school and pass the bar, I think.
Is that
you might just have to go to law school. I'm not sure.
And in her case, Yale Law School, which means this is rock bottom for her career, which it can only go up from here. Thanks for taking a bet on us, Rachel. We appreciate it.
This is more interesting than any law school class I ever went
to. Oh, love that. So our listeners likely won't know you, although they will be probably hearing more of you as the Eightfold case unfolds. But give us a little taste of who is Rachel.
So I'm an attorney at Towards Justice. I'm the associate director here. We're a nonprofit law firm based in Denver, Colorado, but we do national work. We represent workers and consumers in litigation and in other advocacy that builds worker power and advances economic justice in Colorado and across the country. And we do both. Our original focus, I think, was on workers, and we've expanded a little bit to more consumer competition law. And this case is really at the intersection of a lot of those legal spaces.
Yeah, it definitely is. What about you, though, Rachel? Taking a little time on the Bunny Hill there in Colorado. What's going on? What's going on with you? Tell us a little bit about you.
So I have a 3-year-old who went skiing for the first time this weekend. She took her very first ski lesson. I think she went down the Bunny Hill one time in 3 hours. And her report was that the hot chocolate was the best part. So it was a great success.
No ACL sprains or no ACLs fine? I know a lot of that's going down with the Olympics.
As physically unbruised as a 3-year-old can be.
Physically.
Yeah. Mentally something entirely different. Yes. That's what that hot chocolate's for. So if you can you give us a little bit about just kind of like the background of Towards Justice, and also how did you stumble upon this little company called Eightfold?
Sure. So like I said, Towards Justice, we take a broad view of worker power and economic justice, and sort of started learning about these AI hiring companies. It's something I think that everybody who works with workers, who represents workers, has heard about, and sort of understands is a really big issue for the workers that we talk to. They're facing, I think, a lot of difficulties in applying for jobs that they haven't necessarily seen before. So we started looking into these products about a year ago, and we've been working actually very closely with Towards Justice. Has one of our senior fellows is Seth Frotman, who until a year ago was the general counsel at the Consumer Financial Protection Bureau.
Oh, hello.
Yeah, and they had sort of done some looking into these products and actually issued a bulletin about 2 years ago, sort of suggesting that there could be FCRA liability, Fair Credit Reporting Act liability for some of these products that sort of track workers and create reports on them. This case came out of that project, and I think Eightfold jumped out at us because a lot of huge companies use it, and we came across a lot of workers who had experiences with applying to jobs there and with not being able to get jobs with companies that use Eightfold and not understanding why.
So for all of us dummies out there who don't know what FCRA or FCRA, which is what I've been calling it, we don't know what that is. Can you give us a little background on that?
Sure. Yeah, lawyers love a nickname for a law. The Fair Credit Reporting Act is a law passed in the 1970s that governs what information and how companies can use information in creating credit reports that control people's access to credit, insurance, and jobs. So FCRA defines a credit report as information bearing on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. The reason why I read through that, all of that sort of legal language is because I think that until I got involved in this, I thought that a credit report was just like the thing that TransUnion or Equifax or Experience made to determine your access to a credit card or to a loan or whatever. And it's actually a lot broader than that. And the legislative history makes that clear. Legislative history is another sort of lawyer word, which means what the lawmakers who passed the law sort of were talking about and how they explained the need for the law when they passed it. So the Fair Credit Reporting Act was passed in 1970. In 1970, sort of at the very beginning of credit reports as we know them. And at the time that the Fair Credit Reporting Act was passed, credit reports could include stuff like, what your neighbor said about you, what your marital status was, whether you had a reputation as being like a drunk among the people that you sort of that you hung out with. So what FCRA was intended to do was to provide some transparency into this process, right? Like people were being denied credit because their neighbors, said they threw loud parties or whatever.
And not only that, just so I understand, that information was there, but I wouldn't have access to it. So it was sort of we'll say black box more than a few times in this interview. It's there, but I can't see it, which I think comes to the crux of some of this. So I think you've done a great job of setting the table. Talk about the players in this. Talk about the plaintiffs. You're working with another law firm. Like, let's get the players on the field now.
Here at the Chad and Cheese Podcast, one thing that we love is obviously you watching, but also like and subscribe.
Yeah, totally. So Towards Justice is one of the lawyers on the case, one of the law firms on the case. The other law firm on the case is a private plaintiffs firm called Outen and Golden. Again, they typically do employment cases, but this is sort of their employment and consumer law, I think, has a lot of overlap, and particularly these days. So the named plaintiffs in this case, Aaron Kistler and Sruti Bhaumick, are both just workers who have applied to jobs, a lot of jobs, using Eightfold platforms and have really struggled to find a job. They both have a lot of experience. They're both sort of relatively older workers. And they came to us having applied to just hundreds of jobs and been denied for those jobs over and over again and not understanding why.
Well, this sounds, much more layered than the Mobley versus Workday case, where it's literally that to me just seems like age discrimination.
Yeah.
This this seems much deeper from the standpoint of, as Joel had said, collecting all that data and it being in a black box and not being validated and or verified by the actual candidate and or user or consumer or whatever the hell you want to call them, right? But there's literally no validation or verification. And I'm sure you've seen the Eightfold patent. There's a lot of inference that happens.
Exactly.
And so that's got to be, I mean, the patent, you take a look at some of their marketing materials that talks about enrichment data and actually taking from LinkedIn and GitHub and all these different areas, and they're enriching a person's profile. And it's like, well, how do you know that that's valid data? So if you could dig into that a little bit, because this is so much more layered than the Mobley case.
Yeah, and I think the Mobley case is just addressing a different issue. It's also a serious issue. I think there are reasons to think that this AI hiring software facilitates and sort of recreates human biases. And so there are potentially, I think, discrimination cases that could come from this. This is different. This case sort of applies to all users and deals with the right to both to privacy and to transparency, to understanding sort of how your data is being used. And so just based on Eightfold's public information, eventually I think we will hopefully get insight into sort of, private information, be able to test that in discovery. But right now we just have access to its public information. But there's a lot of public information they've put out there about that, about their product. And based on the public information, I think there's two potential issues, both of which would violate the Fair Credit Reporting Act. One is that they do sort of in their patents and various marketing materials talk about these enriched talent profiles. And the enriched talent profiles sort of suggest that they find data from elsewhere on the internet about a specific candidate and add that data to a candidate's profile. I think they've denied that. Again, the discovery will sort of let us explore more into that. And our allegations are based on the public statements that they've made. The other issue, though, even setting aside whether for any individual candidate, they go to your LinkedIn, sort of find, blogs that you've written, whatever their marketing materials suggest, even if they don't do that, for every applicant, they sort of take the information that the applicant has given them, they take the information that the employer has given them, and then they break down that information and sort of analyze it and use that by that analysis, they make inferences about, what jobs are like each other, what job titles are like each other, and what sort of skills an employee is likely to be able to develop, what their career trajectory is, what jobs they're likely to have in the future. And all of those inferences are provided to the employer and the employer sort of used to decide whether or not someone is eligible for a job. And, those inferences are unverifiable, right? Some of them are predictions of the future. And I think that in itself is a credit report under the definition of the credit report. And it feels, I think, very invasive to people to have this machine deciding what you want to do with your career. I mean, maybe it's wrong.
And in case it ever comes out, Chad, that OnlyFans account is not me. It is not me. Okay. Rachel,
check the credit card on that one.
Eightfold is a company with a $2 billion+ valuation. They've raised about $400 million. I assume that they have something to say about this. What has been their response other than just, it's not true?
Their response has been, we are an ethical AI company, and what we use is just candidate data and employer data. Now, I am not the judge of who's ethical or not, right? That's not my job.
Exactly.
I'm a lawyer. My job is to decide whether or not it looks like they're complying with the law. So setting aside whether they're ethical, which is not something that I'm opining on, again, the allegations in the complaint come from their marketing material. They're all cited. You can follow the citations and see the patents. They're all in the complaint. And regardless of whether for sort of any individual candidate, they're only the individualized information is only from, the resume and the employer. Again, these inferences, these calculations, this match score is being compared to, I think their big selling point is, we compare people to 1 billion data points, right? Our decisions are informed by 1 billion data points. I mean, that is a lot of external data that they're using to draw these inferences, to create these reports that say things, like this person has these skills today, but they're likely to be able to develop these skills in the future. And based on the types of companies they've been at in the past, they're likely to go to this type of company in the future. So, I think that regardless of what data they're sort of ingesting about any individual, what goes through their system and then comes out is, I think, a much more expansive report than that. This is not just them sort of reciting what's on someone's resume.
So for me, and obviously Joel and I have been in this space for a long time, we hear a lot of bullshit marketing terms. And one of the biggest bullshit marketing terms we hear right now is ethical AI. There's literally no hard edges around what it actually means. But yet everybody's using it. And I want to dig into this patent real quick because I have it up on my computer. So as you were talking about talent insights, quality of education. I don't know what that means. Does that mean that I get a better quality of education by the different school that I go to? I mean, what does that mean? Career growth progression, skills depth, industry expertise, and then you get into the personality insights. This is kind of scary, okay? Talking about whether I'm a team player, I'm an introvert, extrovert, chess, whether I played chess or, a high endurance athlete. I mean, it's just like, and then there's also the predictions piece that's associated to this. This is all set in the patent that's out there that is the framework of which Eightfold was built on. And yet they're denying all of this.
I think that's exactly right. I mean, there's a lot of information that they have said, and we're just repeating that information, right? I mean, again,
Gotcha.
Everything in the complaint is
Fair.
is cited. We're just repeating it. And I think it feels very invasive to people, and it's, I think, pretty clearly covered by these existing laws. I mean, again, these laws are from the 1970s, but even at the time that they were passed, their drafters were concerned with sort of computerized data collection very specifically. The sort of line that I love is one of the drafters said, the individual is in great danger of having his life and character reduced to impersonal blips and key punch holes in a stolid and unthinking machine. Now, obviously, we've moved past key punch holes, but I think the overall sort of concern is very much coming to bear in these products.
Rachel, this is a class action lawsuit. For those, again, that don't know, sort of describe what that means, how that could unfold, and then maybe what are some historical examples of how these cases resolve.
Sure. So a class action is a structure for a case where a single issue or a single sort of legal concern affects a large group of people all at the same time. So the idea is that, every single person who's submitted an application, who's been affected by Eightfold, could file their own lawsuit. That would probably be like millions of lawsuits, right? That just doesn't make sense from an efficiency perspective. It would overwhelm the courts. None of it would work. You can't afford to hire your own lawyer for that. So a class action sort of aggregates all of those claims together, using sort of the examples of a couple of named plaintiffs, a couple of people that have been affected in the same way as everybody else by the lawsuit. So the way that those cases proceed is generally you sort of go through what's called a class certification procedure, where the court decides if the lawyers are correct, that it's more efficient for the case to move forward all at once. That's often one of the sort of big early fights, is whether you get class certification or not. Once a class has been certified, sort of everybody's claims are in it together. People in the class get notice of their rights, have the opportunity to stay in the class or to leave the class. And so all of that moves forward together. Generally, people don't have to affirmatively opt into the class. If a class is certified, they're a member of the class. So people who are affected right now don't have to do anything in order to sort of stay part of the lawsuit. And then, eventually either it all goes to trial sort of together, or there's a settlement. And then obviously the alternative is that, class certification is denied, the cases go forward on their individual claims. We're optimistic, I think, that this is an appropriate case for class treatment.
So you posted a new job ad. Now you can sit back and wait for the applications to roll in, right? That's why we built JobPixel. Imagine showing candidates why your company is great with real people, real stories, and real culture. With JobPixel, it's not just another job ad. It's an invitation to something much bigger.
Video gives you a 3 times better response rate. So instead of chasing after candidates, they'll be coming to you.
And with a 34% boost in conversions, candidates aren't just looking, they're applying.
And if you're worried about people clicking away, don't be. Our videos reduce bounce rates by 25%. That means they're watching, they're engaged, and they're interested.
282% more engagement. Yeah, you're going to need a bigger inbox.
Finding the right candidate is tough, but with JobPixel, it doesn't have to be. Show your company's authentic story, and the candidates will follow.
Let's make recruiting fun again, because honestly, it could use some help.
Do you want to see how JobPixel can save you time and money while achieving your KPIs? Schedule a demo today.
At Shaker Recruitment Marketing, our comprehensive services include branding, talent attraction, MarTech, and analytics, empowering you to achieve your recruitment marketing goals. We believe in doing things the right way, delivering the right message through the right activation, achieving the right conversion. For us, business is deeply personal. Our legacy is built on relationships. Together with our people, clients, and partners, we've been shaping the world of talent for over 70 years.
So that it seems like, or at least I believe I read that there are over 1 billion profiles within the actual Eightfold system. And this is obviously, we're just going to break it down into, the US. So let's say that there's 100 million or let's say 50 million people who've been impacted on this. How are they notified? Are they notified? How are they notified? And how do you get into the discovery process at this point?
Yeah.
The good news is our listenership is about 50 million. So that'll cover most of the people that know about this now.
So generally when you get a class certified, notice goes out to everybody. I think that we've all gotten sort of like emails in our inbox that say like, this is a class notice, whatever. Often they go to spam.
Postcards.
Postcards, whatever. I actually check my spam pretty regularly as a lawyer who does class actions to be like, am I missing a class action here? Is there something I need to opt into? Or, like submit a claim form to get money, right? I'm not going to leave free money on the table.
All those sales leads in the spam inbox for lawyers. I had no idea. Never thought of that. Yeah.
But anyway, so if a class gets certified, I think generally class notice goes out. And then if there's a settlement, if there's like money, then class notice definitely goes out. Again, it's usually some combination of email and mail. And then in a case that's this big, there may also just sort of be like press coverage where you learn about it. They're sort of like posting ways for a class case to get notified. Generally, though, I mean, one of the advantages is that of a class action is that you don't individually usually have to do anything to participate, potentially unless there's money on the table.
Gotcha.
Is there a website? That's usually something, isn't it? Like
there will be. Yeah, there will be. There's not right now. Yeah, but there's generally a class website.
Well, I think Chad owns Eightfold Sucks if you need that one in the future. Just a heads up.
The defendant usually has to agree, and I do not think they're going to agree to that one.
I won't agree on that one. Sorry, Chad.
That's no fun. That's no fun at all. So going back to the class action side of the house. So back in 2017, I think Talent Ben was in a class action, but they went ahead and settled. So therefore, they didn't have to go to discovery. And to be quite frank, our industry and the world needs discovery because we have no clue at this point because of all the black boxes that are out there, not just Eightfolds. We've got so many black boxes that are out there. There has to be a precedent set. And there's not really, or at least I don't know of one, especially in the hiring space, where there's been a precedent set. How do you, I mean, because this is no pressure. This is on you, Rachel. How do we make sure this gets to discovery so we can actually see the data and see what's happening so that companies that are currently doing it can stop, number one, and number two, ones that want to get into this space start to understand, oh shit, maybe we need to do some redesign.
So as lawyers representing a class, it's our ethical obligation to sort of, achieve whatever result we think is in the best interest of the class. Sometimes that does mean early settlement. If, for example, I'm not saying that this is what happened in that case. I'm not saying that this is what happened in any specific case. But if sort of the defendant comes and says, we messed up, we're going to change our practices. Let's sort of get this resolved before there's a lot of expensive litigation, then maybe you'll reach an early settlement. I mean, the other reason why you might reach an early settlement is that you realize your case isn't as strong as you thought. So there are potentially there are situations in which you reach a pre-discovery settlement, and that is the best sort of the best outcome for your class. As lawyers, I think that we are, towards justice, we do litigation. We are in the public interest. We are sort of trying to affect policy and sort of bring attention to issues that we think need more light. And I think this is one of them. But we ultimately have the responsibility sort of to the class to get the best possible result for them. And litigation is expensive, right? So and discovery is expensive. So there are, I think, incentives on all sides to settle early before all of the money that could potentially go to the class ends up going towards, actually the legal battle. So, I can't know how this case is going to shake out. And we have, again, we have obligations that aren't just sort of purely get to discovery. That said, I do think discovery is a really important way to shine light on a lot of these issues, and is one way that litigation can help advance the public interest.
Rachel, this was filed in California. Explain to me again, as a layman, it'll be tried in California if it goes to court, and then can other states use it as precedent? How does the federal, because it's a federal law, like explain that to me. Help me make sense of that.
Yeah, so the case was filed in California, and it's under both federal and California law. I think that the class is defined as sort of all everyone who was affected by Eightfold nationwide. They're sort of the California claims only apply to people in California because that's sort of how state law works. FCRA applies to people nationwide. I can't remember off the top of my head how we sort of defined the class. I think it is a nationwide class, so it would affect people nationwide. But it is also common, I think, and there are other state laws that provide similar protections to workers in other states. I think that there's a potential for follow-on cases in other states as well.
And historically, I mean, this is a company that serves global clients. Could this be a springboard for, say, the EU or other international governments to look at this and say, like, we're going to do the same here because that's an issue here? I mean, that's a real existential threat to any AI company, I would think.
Oh yeah.
Yeah. So I'm not a U.S. lawyer, right? I'm a U.S.
We won't
Esquire.
hold your feet to it. I asked historically, like this happens. I said.
Yeah, I mean, absolutely. And I do think that the EU does have some stronger privacy protections than the U.S. in a lot of ways.
They do.
It's my understanding they are looking into these AI companies and these AI hiring platforms. And so I do think that is an issue that all of these companies need to be aware of.
And I'm sure they are paying attention to the news and seeing the headlines all over the place.
Are you saying they might have added motivation to stick it to our AI companies, Chad?
Could be.
Rachel, we have a lot of employers listen to this show, and many of them are using, if it's not Eightfold, it's some other AI black box. We can magically give you the perfect candidate for every job. What kind of risk? You mentioned Microsoft, I think, as an Eightfold user and part of this case. Correct me if I'm wrong, but like, what employers are freaking out about this stuff? What would you tell them in light of this case?
So This case, the case that we have brought is just against Eightfold. It's not against any of the employers. That said, I think that there is potentially liability on the part of the employers. One of the things about the Fair Credit Reporting Act is that it imposes potential liability both on the people that use the credit reports and the people that create the credit reports. So I do think it's important to understand what these rights are. They're fundamentally, they're disclosure and correction rights. So I think employers should be aware of what those rights are and just make sure that they're complying with the law and providing applicants with all of the rights that they're entitled to.
Well, it's interesting that you say that, and it's a great question, Joel, because on the Mobley versus Workday side of the house, they had asked for client lists of Workday clients that were actually using aspects, AI, quote unquote, AI aspects of the product. So, I mean, Joel and I have talked about this for years. Many laws actually hold the employer responsible solely. We're starting to move to a shared responsibility where these black boxes are being, created, although that doesn't leave the employer off the hook because they should be doing the due diligence and the constant auditing and looking at analytics and also their hiring cohorts to really understand what's happening in the black box. I find this really, really interesting. But there are so many other things that are happening out there, and I'm sure you already have a full plate as it is. But there are companies that are asking, or actually forcing in some cases, employers to provide hiring signals back to train LLMs, right? So large language models. And for me, that's way too far, right? To be able to actually take these hiring signals. I mean, first and foremost, the employer shouldn't be giving to them, but as a candidate, and that attached to me in all of these different systems, if these hiring signals are training large language models, I have no clue that this is happening, right? This is, again, the whole Fair Credit Report thing.
Absolutely.
I have no clue that this is happening. It sounds like there could be prospective impact in many other areas of large language models, training and such.
I think that's absolutely right. I think that using this data to train large language models, and again, that's one of Eightfold's big selling points, right? Is that they train their large language models on 1 billion skills, 1 billion people, et cetera. I think that there is potentially significant liability there, and that employers, as well as the sort of reporting companies themselves, really need to be aware of that and think through that very seriously.
Done. I think we'll cover speed and hiring.
Did somebody say speed? Then buckle up, boys. You're about to learn how to hire fast.
Who is that?
Vetty Betty. From Vetty, the hiring acceleration platform. Come on, man, keep up. What's up, Betty?
Hey, Chad. Vetty makes high compliance hiring easy. Background checks, licensing verifications, and health screenings, all in one place. Real-time updates, no red tape, and no delays. Hiring managers can move fast, stay smooth, and close the deal.
So they just sit back and watch. Hell, I could watch this all day.
That's right. Relax, enjoy the view, and don't lose the hire. It's that simple. With Vetty, it's all taken care of before they can even catch their breath.
Best lesson ever.
Class dismissed, boys. Vetty. Hiring as it should be. Visit vetty.co to learn more.
Rachel, we have a lot of people who use LinkedIn, and I want your opinion on LinkedIn is a model where someone voluntarily gives their profile, creates an account, and then I guess LinkedIn could do some sort of a ranking of people based in their system.
Yeah.
Do you view a LinkedIn as susceptible to cases like this, or are they sort of immune because you're voluntarily going onto their system, you're agreeing to their terms of service, which I assume they say we can do whatever the hell we want in terms of algorithms and whatnot. Like, do you think LinkedIn is immune to these kinds of cases? Could LinkedIn be legally bound to showing people like a credit report what they are showing employers or what employers can access in their algorithm? Like, where does LinkedIn or maybe even an Indeed, which has a really big database, where do they play into these cases, if at all?
So I don't want to, this is a very lawyerly answer. I don't want to sort of make any comments on LinkedIn's specific potential liability. But generally speaking, I mean, we all agree to so many terms of service. We are all bound to sort of infinite word count of these sort of fine print terms for every single thing we do online. That said, one of the things that's really powerful about the Fair Credit Reporting Act is that it requires not only sort of consent, like, you know, the sort of click-through consent that companies get from you all the time and you have no idea what's in there. It requires standalone and clear and conspicuous disclosures. So this sort of click wrap type of disclosure, type of agreement that we're all agreeing to all the time via those little pop-up terms of service boxes, that is not good enough. FCRA requires the sort of FCRA disclosures to be made separately from any other disclosures. They can't sort of be buried in a long contract, and they need to be clear and conspicuous. They need to be in a sort of format that people will read and understand as disclosures about this specific thing. So I think that's one of the things that's powerful and helpful about FCRA is that you can't just sort of bury the disclosures in the fine print contracts or behind the little hyperlink that says terms and conditions, or, you know, all of the various ways that that companies sort of get you to agree to these contract terms.
Those bastards.
Oh, Rachel, you've given us so much to think about. Rachel, this is Rachel Dempsey, Esquire, from the Towards Justice, the Associate Director. So now, Rachel, if there are, I don't know, prospective class action suit clients who want to reach out to you, want to find out more on what they should do because they feel like they've been impacted, how would they actually reach out to you and start that process?
Yeah, so you can find my my contact information on the Towards Justice website. That's Towards with an S, which is something that I have to explain like at least once a week. But yeah, my contact information is available there. Our intake form is available there, and we would love to hear from people.
Chad, I have a sneaking suspicion that we will hear from Rachel again in the future. That's another one in the can, everybody. We out.
Thank you for listening to, what's it called? A podcast. The Chad. The Cheese. Brilliant. They talk about recruiting. They talk about technology. But most of all, they talk about nothing. Just a lot of shout-outs of people you don't even know. And yet you're listening. It's incredible. And not one word about cheese. Not one. Cheddar. Blue. Nacho. Pepper Jack. Swiss. So many cheeses and not one word. So weird. Anywho, be sure to subscribe today on iTunes, Spotify, Google Play, or wherever you listen to your podcasts. That way you won't miss an episode. And while you're at it, visit www.chadcheese.com. Just don't expect to find any recipes for grilled cheese. It's so weird. We out!